why a child needs an advocate?
Well, I could answer that, but Bob is here. Why do you think children advocates?
Bob, who's a volunteer?
Well, in a general statement, these are kids who need protection
From
by the courts for various reasons. These situations that are going on in the home, or perhaps in the home as well as some other places where the kids find themselves.
now, Bob, are you the advocate for one child or more than one?
The way this goes is we, as a volunteer, choose a number of so-called cases. Mm-hmm. Now, depending upon the time we have to devote to it or whatever, and within each case, you may have one child, or in one case that I have now, there are 4 children.
Yeah, 4.
Yeah, and in another case. So that obviously makes it a little more complex.
Yeah.
Because you got to go around and you got to talk to an awful lot of people.
Yeah.
You see, in the interest of all these 4.
Michelle, is it typical for advocate to have more than one child?
Yes. In fact, our expectation is that people will take 2 cases. What our training program in Hennepin works is you take your first case halfway through training. So halfway through class, we ask you, you're still committed, this still sounds good, and we really give you the second half of class to work that first case to see if it's a good match. And then at the end of the class, if you're willing, we ask you to take a second case right away. Our actual requirement or our expectation is 18 months, a year and a half commitment. And the year and a half commitment is really important because we want to make sure volunteers follow our children all the way through the child protection portion of a case. In most cases by state statute, that's about 12 months. In 12 months, a judge kind of has to decide, and the people at the table have to decide whether we think kids are going home if the case is still, or if they're going to relatives, or staying in foster care, or looking at some other kind of arrangement. So at 12 months is kind of that magic time where that decision really needs to be in the rolling. But sometimes families aren't quite ready to take their kids back if they're in foster care then, or haven't done certain things to close a case if the children have never been removed. So we acknowledge that we really want those extra 6 months in terms of volunteer commitment to make sure kids really are stable. They're where they need to be, hopefully for the rest of their lives before we close a case. We ask for a year and a half commitment, and again, 2 cases in that period of time.
Well, tell me, and Bob may be suited to answer this question also. Let me throw it out. Specifically, what does the advocate do?
Okay. The volunteer, by definition, is a court-appointed special advocate, which, of course, means that you advocate in the interest of that child. Mm-hmm. You find out in various ways what is in the best interest of that child for that child. Mm-hmm. And in this case, concentrating on the child rather than other aspects of the situation.
Do you go to court?
Oh, yes, you do. Now, after being assigned the case, you might say, you would then get in contact with the various people who are involved with the family, meaning the family members themselves, perhaps, any teachers, counselors, and whatever, medical people, whoever's involved in that child's life, you would get in contact with those persons to find out what kind of situation the child is in and what kinds of recommendations they're making for that child, and to try to find out what that child's needs are.
What do you do with that information?
You take that information and you report essentially back to the judge, because you're appointed by that judge to do it. Mm-hmm. And so after gathering all that information, you report back to the judge those things, not necessarily all those pieces, but what you report back to is what you think is in the best interest of that child based upon all those facts you've gathered.
Now, does the judge really care what you have to say?
That's the interesting thing about it. Oh, yes. Oh, yes. I was told that, but I was very, very pleasantly surprised to know that they do. As a matter of fact, they depend upon you, essentially. The very first case I had, I went in there, of course, where the other entities, maybe the county attorney and the social workers and the person's lawyer, kid's lawyer or something of the sort. And I had a somewhat different opinion about what ought to happen to this child. And I'm really relatively new. And I was pleasantly surprised that the judge took my recommendation simply because it made sense. Because I supported it with the information that I gathered.
Do you make any decisions?
No, you don't make decisions, you make recommendations. You see, regarding that child. And you support those recommendations with the facts as you found them.
And the judge, and again, the judge cares about
what
you have to say.
Oh, yes. The judge will ask you during that trial what it is you have to offer, and may ask you specific questions as well.
Michelle, how does GAL decide what's best for the child, or is that a decision that GAL has anything to do with?
No, I think that making that best interest decision in terms of what the recommendation is about all the parties at the table. You're going to be asking birth parents, relatives, the family members, the caseworkers, everybody in the case what their thoughts are, and at some point you're going to either agree with some of those thoughts or all of them or none of them, or kind of come to your own position. And really the expectation as that advocate is to have a separate position, separate fact gathering from the other entities, but to be in collaboration. Guardians are 1/3 of the party in the case. The other parties are the social worker and their attorney, that's one party, and then the attorney for the parent, who is also making a recommendation. So the judge is listening to 3 voices, and yours is one of the voices. There are also cases, children who are over 10 do have a right to have a lawyer that represents them separately from their guardian. And in those cases,
over 10,
over 10 years old.
What about under 10? Whatever.
Under 10, we represent them. Yep. And they are allowed over 10 to be in court. And basically the difference can be in those cases that we are looking at needs. What does the child need? So if we happen to be in disagreement with the child in terms of what they want, we still tell the judge, this is what the child wants. This, however, is my also informed opinion about what the child needs. And then it's really up to the judge to take that into consideration along with the other 2-party recommendations.
Now, you say if they're over 10, they can go to court. Who makes the decision whether the child goes to court or not?
The child, social worker, professionals, if they're involved in maybe therapy or other kinds of settings, people might decide that even at 10 it's not really good for them to see what's really unfolding. So it's based upon their kind of abilities to be there and to be able to process the information and not be, really negatively affected by watching that court process. A lot of stuff is said in court that sometimes especially younger children should not hear.
So if they're 10 or under, they absolutely do not go to court?
Rare situations, but no, that's not the process.
Do you find that, or you or Bob, have you found that in court, and when the kids do go to court, this is a good or not so good, healthy or not healthy for the kid to be in court?
Well, it's the truth. And I think that sometimes it's a difficult truth to hear, and certainly what is written, which may not be favorable to families, but it's also the experience that the child is living. So overall, I think it's very positive, especially long-term effects that the child is there and they were involved in the process of making decisions about their lives. And I think for those of us who have been in foster care, that's very important, is that somehow we feel that we are involved in that process. And that's something that society hasn't come to very quickly, about kind of kids having to want to have some kind of say in their future as children.
I believe I heard you mention before we were on the air that you had when you were a youngster, you were exposed to the GAL system?
I was not, because I was actually in foster care before the Guardian program started in 1978 in Minnesota. And that's a part of why I do this work, is that it makes perfect sense to have another advocate, somebody in court who, social workers are there to help the parents with the case plan as well as to look at the child's issues. So their vision sometimes is split between the adult needs on the case, the parent, and the child's needs. The attorney is there to say whatever it is that the parents want them to say. That's what their job is. So really that advocate is the person in the middle to say, understand that family has needs and this child is a part of this family, but I want to look primarily at this child and what they need and to represent that in court. And that didn't used to happen. That did not happen when I came through the system. So I think it's a wonderful thing, and that's why I both work full-time for this program but also take volunteer cases as well. I believe in it that much.
And so you are the ideal person.
Well, I think every person who's interested is the ideal person.
Don't be modest.
I have a little more experience.
Oh, okay, okay.